So welcome back, everyone. Now that Seth has talked a little bit about how OGE can assist you and flag some key ethics documents for you, I'm going to talk through some common laws and regulations that might come up in your investigations. After that, as we've mentioned, we're going to talk through a simple fact pattern involving some ethics issues and work through how to best approach those facts. But before we do that, I'm going to give you a brief overview of some of the major ethics laws and regulations which might come up. Slide 18, please. So this slide lists some of the major statutes and regulations that can come up in IG investigations. I'll break each one down briefly in the next few minutes. Now, this is far from an exhaustive list, but it should give you a good starting point regarding the kinds of ethics issues that can come up for you. And as you can see, ethics rules come from a variety of sources. Seth mentioned this: criminal statutes, executive orders, and the regulations governing government employees, such as the standards of ethical conduct. And there are, again, as Seth mentioned, a number of other criminal conflicts statutes. But to prevent this training from going into dinner time, we're just going to focus on one statute and a few ethics regulations here. Slide 19, please. First, we're going to talk about 18 USC 208, which is, as Seth mentioned, our primary conflicts of interest law. This statute prohibits a government employee from participating in a particular matter that affects that employee's financial interest or the financial interest of someone close to that employee, like their spouse or an employer. Simply put, 18 USC 208 means that government employees can't work on things they know will affect their financial interests. In other words, you can't make money off your government job. And at its simplest level, this law is intended to prevent government corruption. Slide 20, please. Here's a visual representation of the major questions that you would want to ask when it looks like an employee might be benefiting financially from their government job and there might be a 208 violation. So first, is there a particular matter? Matters are things that government employees are working on. And we're concerned here about two types of particular matters. First, those that involve specific people, like an investigation or a contract. And second, those that are focused on a specific group of people, like a regulation affecting the trucking industry. Particular matters, which are the ones that we're concerned about here, are not broad policy initiatives that affect large and diverse groups. Healthcare legislation and tax reform, for example, would affect almost everyone and thus are not particular matters. So if the employee is working on something that affects either specific people or a specific group of people, they're working on a particular matter. So second, is that employee's participation personal and substantial? For this element, you need to determine if the employee is participating directly in the matter and if their involvement is significant. Generally speaking, anything beyond administrative involvement is significant. There's a low evidentiary bar for this element. And finally, does the employee have a disqualifying financial interest? And for purposes of 208, there are two kinds of financial interest that we're concerned about. First, a personal financial interest is one held directly by the employee, like the employee's investments, their businesses, their debts. Second, imputed financial interests are held by specific other people, the employee's spouse, minor child, employer, and those with whom the employee is negotiating for employment. The financial interests of those people or entities are treated as if they are the same as the employees for the purposes of 208. So, if an employee has either a personal or imputed interest in an entity involved in a particular matter that they are participating in, there's a 208 issue. For example, let's say we have a DOJ attorney who's working on a criminal prosecution of a large company. She owns stock in that company. Do people think that that is a 208 violation? Anyone have any ideas? You can feel free to put it in the chat or raise your hand. Okay, I'm seeing some yeses. Yes, that is the answer. Yes, this does implicate 208 because the employee is working on a particular matter, the criminal prosecution, that would have a direct effect on her financial interests because she holds stock in the company and the stock value could be affected by the investigation that she's doing in her government job. But the analysis does not end there. Slide 21, please. Okay, so there are multiple different ways to remedy a 208 criminal conflict. The first is a waiver. As Seth mentioned, the 208 statute allows an agency to make a finding that employee participation in a matter isn't likely to affect the integrity of that employee's government service, and they can then waive criminal liability. And in doing that, the agency would weigh a variety of factors, the amount of stock, the employee's importance in the matter, and then determine whether or not a waiver is appropriate. Waivers have to be issued before the employee begins work on the matter. Otherwise, the employee has already violated 208. And I do also want to note that waivers are generally seen as a last resort remedy, and they should be used only if no other remedy makes sense. So what are those other remedies? One is applying a regulatory exemption. OGE writes these exemptions into our regulation that implements and interprets 18 USC 208. When we write an exemption, it's because OGE, our office, has made a determination that the type of interest is so inconsequential that it just doesn't raise ethics concerns. We're not concerned about it. So some examples of these exemptions include diversified mutual funds, employee benefit plans from an employer, or small amounts of stock, anything under $15,000. So in this case, the DOJ attorney owns only $10,000 of stock in the company she's investigating. So the small amount of stock or de minimis exemption would apply. And the DOJ employee could work on the investigation without violating 208. However, if the DOJ attorney's spouse also owns $10,000 of the same stock, that interest is then imputed to the DOJ attorney. So, in other words, we consider it to be the same as if it were held by the attorney herself. So, the total interest would be $20,000, which is more than that de minimis exemption. That's up to get to $15,000. And then participating in the investigation would violate 208. So specific numbers really matter when you're looking at stock holdings. So let's assume that this is the case. The DOJ attorney and her spouse own $20,000 in stock in the company that she's about to be investigating, and there's a 208 conflict. They can't use the de minimis exemption because the amount they hold is too high. What other remedies are available? As we discussed, a waiver is an option as long as she hasn't started participating. Other options would be the employee could divest. She could sell the stock. That completely makes the conflict go away. Another option is she could recuse. The employee could not participate in the investigation. And any of these approaches would prevent a criminal violation. So as you can see in this example, when there's a 208 issue, there are a lot of ways to resolve it. And ideally, the ethics office should be working with the employee proactively to identify the issue and figure out the best remedy. Slide 22, please. Now I want to take a step back from the criminal laws and talk about some of those basic ethics principles that are derived from the executive order Seth mentioned, signed by President George H.W. Bush in 1989, entitled The Principles of Ethical Conduct for Government Officers and Employees. That executive order was codified in our standards of ethical conduct. Specifically, 5 CFR 2635-101 states that public service is a public trust, which you've probably heard that phrase before. And it then restates the key ethical principles known as the 14 principles that are laid out in the executive order. And as Seth mentioned, these principles are broader than the conduct that the criminal laws prohibit. Next slide, please. Some key principles listed in 2635-101 include employees should not use public office for private gain, employees shall act impartially, and employees shall endeavor to avoid any actions creating even the appearance that they are violating the law or the ethics standards. These principles are the broad strokes and bedrock requirements of the ethical standards of conduct, while some other sections of the standards address more specific ethics rules and requirements in certain areas. Slide 24, please. Now, these broad strokes expectations from subpart A are important because there are many situations that are not clearly covered by either the conflicts of interest laws or even the regulations we are going to discuss. And this portion of the regulation explicitly directs employees to apply the principles to determine if their conduct is in keeping with standards of ethical conduct. Slide 25, please. And as you can see from this slide, these general principles can be enforced. Other than the misuse of position rules, which we'll talk about in a minute, violations of the general principles are the most common basis for disciplinary actions based on the standards of conduct over the last 10 years. Slide 26, please. Okay, so now I'm going to talk about one of the most common, more specific requirements in the standards of conduct, 2635-502, which requires that employees take certain specific steps to avoid an appearance of a loss of impartiality. Slide 27, please. As a reminder, here's the underlying obligation from the ethical principles. Don't give preferential treatment to anyone in your work, and don't do anything that creates the appearance of violating the ethics rules. But the question is, we're trying to prevent this behavior. How do we prevent folks from being partial or providing preferential treatment? Slide 28, please. The answer is in 2635-502, which requires employees to think about whether their involvement is appropriate when certain persons are involved in a government matter. So specifically, if a person's asked to participate in a matter that could affect the financial interests of someone in their household, or a matter in someone in which they know they have close ties to is participating, that employee has to evaluate whether a reasonable person would question their impartiality, their judgment. Slide 29, please. Okay, so this slide looks a little bit complicated, and it is a little complicated. This explains the process for the 502 analysis, which I will illustrate with an example, but I wanted to note at the onset that this regulation is very difficult to enforce. I have consulted numerous times with IG investigators dealing with facts involving a government employee who appears to be not acting impartially. They seem to be favoring someone that they know in some way or something like that. And it's difficult to enforce this regulation. So I just wanted to flag that for you up front. And I'll explain a little bit more about how that works. Okay, so first, an employee is asked to work on something that would impact someone with whom they have a non-financial relationship, a former employer, for example, or a member of their household, or a close relative that is not their spouse or minor child. That would be covered in 208. These relationships don't directly impact the employee's financial bottom line, but they're close enough that it could look bad for the employee to be working on a government matter affecting such people. So let's return to our DOJ attorney who's working on an investigation. Only this time, instead of her and her spouse owning stock in the company, now it's her sister's company. So while the DOJ attorney's sister's financial interest might not affect the DOJ attorney's financial interest directly, it certainly is a close enough relationship that it could look bad. And a close relative is, in fact, a covered relationship under 502. So That would mean that the DOJ attorney needs to evaluate whether a reasonable person would question her impartiality in investigating her sister's company. Now, it's very important to note that the rule doesn't say the employee can't participate in the matter. Instead, what this rule says is that the employee needs to think about whether a reasonable person thinks that they could be impartial. So in this case, let's say the DOJ considers the facts, discusses it with their ethics official, and decides not to participate in the investigation. That's really how this rule is supposed to work. The other thing that can happen is that an ethics official can make a separate determination and require the employee not to participate. So let's say the employee brought this matter to their ethics official and said, I don't think anybody would really care that I'm investigating my sister's company, not my company. And the ethics official can then say, actually, no, I disagree. I think a reasonable person would care. I think they would question your impartiality, and I am requiring you not to participate. The ethics official can also make that determination if they find out independently from the employee that this relationship exists. But either way, whether the employee has determined that they shouldn't participate or an ethics official has made an independent determination, the DOJ employee then must recuse until they receive not until they receive a written authorization to participate from that ethics official. So that's how 502 works. But again, just wanted to, looking at all these steps, wanted to explain that given that this rule doesn't prohibit an employee from participating and instead requires the employee to make the determination about whether or not they participate, and the ethics official can only require that they not participate if they know about the conflict in the first place, either from the employee or otherwise, it really can be very difficult to enforce in practice. Slide 27, please. It's also worth mentioning that an employee can apply that same reasonable person test in other situations that might raise an appearance issue, but don't fall into those covered relationship categories we just discussed above. But in those cases, there's no requirement that the employee do that. Furthermore, ethics officials cannot require the employee to recuse in circumstances other than the ones we just discussed. Okay, so that is how 502 works. Now let's discuss the other regulatory provision that comes up a lot in IG investigations. I'm now slide 28, please. And that is subpart G, misuse of position. Slide 30, please. Okay, so subpart G, the misuse section, gives some more teeth and more specifics to this general principle that employees should not use public office for private gain. And when we say private gain, it often does mean financial gain, but it doesn't always mean that. Private gain includes non-financial benefits, such as, for example, writing a letter of recommendation for someone or pressuring your employees to vote for another employee for elected office. I'm now to slide 30, please. There are a number of types of misuse of position that are prohibited in subpart G, and I'm just going to go through them and explain some brief examples. So first, there's the use of your office to induce a benefit for yourself or someone you know. So for example, working at the Social Security Administration and asking that your friend's application for a Social Security benefit be moved to the front of the line. That's a great example of 702. Second, there's the appearance of government sanction or endorsement. You can't write a letter of recommendation for a personal friend on your government stationery, and you can't appear in a commercial for an electrical appliance and endorse it as an employee of the Consumer Product Safety Commission. In addition, there's misuse of non-public information. So you can't tell your friend who is bidding for a contract at your agency what terms a competing proposal offered, for example. In addition, there's misuse of government property. So, for example, using a government rental car to drive from city to city, competing in marathons because you have a marathoning addiction. That is an actual case I dealt with years ago and is a great example of very clear misuse of government property. You are not allowed to do that. And then finally, there's misuse of government time, including that of a subordinate. So, an employee manager cannot ask their staff to run personal errands for them during business hours. There's obviously numerous other examples, but those are the broad categories of the types of misuse we're looking for when we're talking about Subpart G. Okay, slide 31 or slide 34, please.